हरिये कृपया प्रारंभं करोतु।
Yes. One second. Am I there? But I don't know why it's logged out again. I'll just start now.
करोतु कृपया।
Okay. Namaste and very warm welcome to everybody here. I will just start with Shanti Mantra, which is the Shanti Mantra of a lot of Upanishads, which is just invoking well-being. Okay, so, Om Bhadram Karneभिः शृणुयाम देवाः भद्रं पश्येमाक्षभिर्यजत्राः स्थिरैरङ्गैस्तुष्टुवागुंसस्तनूभिः व्यशेम देवहितं यदायुः स्वस्ति न इन्द्रो वृद्धश्रवाः स्वस्ति नः पूषा विश्ववेदाः स्वस्ति नः अरिष्टनेमिः स्वस्ति नो बृहस्पतिर्दधातु ॐ शान्ति शान्ति शान्तिः। अस्तु।
बहु बहु धन्यवादः आर्ये आगमनार्थं। तर्हि अद्य आरम्भं कुर्मः। We welcome all the participants to join with us, although everybody has a busy schedule. So today is the third day of our workshop. We have our Anil sir, Mr. Anil Kumar, Principal Scientist at CSIR-TKDL Unit, Ministry of Science and Technology. So today, sir will talk about intellectual property rights. What are the different IPR? Sir will explore and discuss with different case studies and examples. So sir has extensive experience as an advocate and with degree of biotechnology, management, business, law. So sir will talk about the IPR. So that's a very important part of our workshop. So we request all the participants, please listen carefully and complete the session. After that, please participate in the assessment session. Then we will go to the next part, that is question and answer session. So please, sir, please take over and start.
Thank you, Piyushi. Good afternoon to all the participants. Namaskar. Let me share my presentation first. So is my presentation visible to all, Piyushi? Can you see it?
Yes.
And it is moving also?
Yes.
Okay. So good afternoon again. Today we are going to discuss the fundamentals of intellectual property rights. So in this program, as you all know, today is the third day, and hopefully we'll go through all the IP tools that are available for protection of creativity. And during this session, we are going to have first we'll have a presentation for 50 minutes, then we'll have a multiple choice question test containing few questions, and then we'll take the questions from the participants. So if we talk about the intellectual property system, so when we talk about the intellectual property system, it's a legal framework. It's a legal framework which comprises of various institutions which implement laws for protection of creations. And these creations are basically the creativity of mind, which may include inventions. They may include literary or artistic works like poems, like novels, stories. They may also contain designs. They may contain symbols used as trademarks, and several other items of creativity. So basically the system, when we talk about IP system, which comprises all these creative items, it protects these items through various various laws, which includes, specific domestic legislations, which are enacted by the government for protection of these creativities. And if you talk about the prime motive, the prime motive of having these IPR systems to encourage creativity and innovation. So when we talk about doing inventions, it requires a lot of effort in terms of manpower, in terms of investment. So until or unless these inventions are not protected, okay, then the people who are making efforts will not be motivated. So the inventions which are, the creation of these, creation of the creation of the the creators who invented these inventions, so they have to be properly compensated. So they must get a fair return on the investment that they have made, which can be further used to make advancement in the existing inventions or the creativities that they have. So it's a kind of cycle which is being followed across the globe. And when we talk about, the tools of IPR, so these are basically copyrights, which protects the literary and artistic creations. They also contain patents, which are given for inventions. The IP tools also include trademarks. These are the legal rights given to the marks or signs, which are used for distinguishing the goods and services of one from others. It also includes industrial designs, which are given for the aesthetic aspect of industrial articles. It also includes geographical indications, which talks about the reputation and characteristics of goods, which is attributed to a specific location. It also concludes plant variety protection. So we are going to discuss all these tools one by one. So to start with, first we'll talk about patents. So most of us, we all know that patents are granted for inventions. So whenever you have a solution for an existing problem, okay, so it can be a product, or you might come up with a process which 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 is doing something very innovative. So patents are basically granted for inventions which can comprise both product and process. So there is no limitation with regard to these two items. And if you talk about the purpose of granting patents, as I already did, talked, these promote technological innovations. So whenever there is a patent granted, it must be a technical advancement over the existing technology that we have in market. So to give it in a better this thing, we have an invention. So if you see this cycle, so there is an example given in the right side bottom of the slide. So there is a bicycle which was granted a patent in the year 1900. Although it is very old, but if you see the mechanism of this cycle, it includes a kind of cycle which is combined with a roving mechanism. And the seat of the cycle is also movable, so it can go forward and backward. So it was a kind of innovation that was granted patent in 1900. Okay, so we all know that cycle existed at that time, and the roving mechanism was also known. But the kind of effort that was put into combine these two elements beyond normal capability of a mechanical engineer, that was the reason it was granted. Okay, so it was a kind of inventive technological advancement over the existing cycle that existed at that time. Okay, so the first purpose is to have technological innovation being going. Then another purpose is for another purpose that patents grant is the fair commercial rewards to the inventors. So when we talk about a patent, so once a patent is granted, it remains in effect for 20 years. Okay, so this 20 years is like nobody else can use that patent until or unless the owner of the patent authorizes the person. So in a way, it gives control over your invention for a limited period of time, which is 20 years, wherein you can get a fair reward over the investment that you have made in terms of the intellectual input or the investment that you have made for making that invention possible. Okay, and the most important purpose of granting a patent includes the documentation and publication of technical information. So when we talk about creating a balance between the inventor and public at large, So there are two elements. One is like you disclose something which you have made that should come into public domain after 20 years. Okay. So the disclosure should be in a way that a person who is not highly skilled in that technological domain can work it after 20 years. So there is a kind of arrangement between the public at large and the inventor that you disclose what you have made, you will get a protection for 20 years over that disclosure, and after 20 years that will be open for the public to use or practice. So therefore it is said that patent should be granted over a properly disclosed invention. Okay, so now we'll talk about the requirements of a the requirements of an invention. So the most important thing is like when you are applying for an invention, the subject matter of that invention must be patentable. Okay, so it should not fall within section 3 of the Patents Act and section 4, which we are going to discuss after this slide. Okay, so it must fall within the patentable subject matter. Section 3 of Patent Acts bars certain kind of inventions from being registered. Okay, the another requirement that is essentially required for getting an invention is like it must have novelty. Okay, so novelty is like it must be new. Okay, so when we talk about novelty, it is like the subject matter or the invention should not be disclosed before the date of priority. That can be the filing date. Okay, so in case you have applied for a patent on a specific date, okay, so that invention must not be disclosed before that date. In case it is available in public domain, in any of the ways, then it tells your novelty. So it has to be novel at the date of filing the patent. When we talk about inventive step, it should be non-obvious to a person skilled in the art. So as we discussed this invention, which included a bicycle and a roving mechanism. So when we talk about the inventive step, then it should be beyond the normal capability of a mechanical engineer to do that invention. Okay, so it should not be basically obvious to a person who is working in that domain. So it requires, it must have certain kind of intellectual input, which is beyond a normal capability. So in case it is normal to do by a person working in the domain, then it is obvious and it is not qualifying the inventive step. And the last essential characteristic that is required is the industrial applicability. So whatever we are filing for grant of a patent should be industrially applicable. There must be a degree of utility in that patents. So this, if you see the statutory definition of patents of invention, it talks about it includes new product or process involving an inventive step which is capable of industrial application. So it includes these basic requirements essentially required for getting a patent. So as we had discussed, there are certain restrictions under section 3. So there are a list of inventions which although may be invention but they are not patentable under Indian law. So this section 3 is from Indian Patents Act. Okay, so this the first invention which is excluded from grant of a patent is frivolous inventions. So when we talk about frivolous inventions, so something which is like which is contrary to well established principles or natural laws are not patentable. So to give you an example on this point, if we if we file a patent application which talks about having a machine with perpetual motion without any input, so this is something frivolous which is against the principles of thermodynamics. Therefore those kind of this kind of patent is not registrable in India. So the another bar is under section 3b, which says something which is contrary to public order or morality or which causes serious prejudice to health of human, health of human, animal or plant life or environment is also not patentable. So if we talk about something which is lethal, if we have invented a lethal chemical which is causing serious prejudice to the health of human or animals, that is also not patentable in India. Okay, so now section 3C, if we talk about section 3C, it talks about the discovery of scientific principles or discoveries principles of discovery of living things or non-living substances in nature. So we must understand that there is a difference between discovery and invention. Okay. So in case we discover something which already existed in nature, so that is not an invention. Okay. So for arriving at an invention, you have to have some kind of intellectual input in it. So in case you are discovering something, you have discovered some kind of metal or some kind of biological material which already existed in nature, that is not patentable in India. So it's a mere discovery, not an invention. Okay. So section 3D says discovery of a new form of known substance or new use of known substances are also not patentable in India. Okay. So if we have a drug which was already known for treating a disease, so in case we come up with a new application of that drug, that is also not patentable in India. Okay. So there have been a lot of cases and a lot of discussions over section 3D in India. The another bar under section 3 is like something which is mere a mixture of two elements which leads to aggregation of properties, that is also not patentable. For example, we know that a single ingredient is useful for treating one disease. Okay. And there is another ingredient which treats a separate disease. So combining those two elements will lead to a composition which can treat two diseases. So it's a kind of mixing two elements without any kind of substantive increase in the results. So those kind of mixtures are also not patentable in India. So with section 3F says mere aggregation or duplication of devices working in a known way are also not patentable in India. So if you see, if we come up with a fan having a lighting mechanism wherein both the fan and the light can be managed as a single device, that is also not patentable because it's a mere aggregation of two devices and the functioning of both the devices is known. Okay. So mere aggregation or duplication is not leading to a inventive output. Therefore, it is not patentable. Apart from that, methods of agriculture and horticulture are also not patentable in India. Then surgical, curative, prophylactic, diagnostic or therapeutic processes which are being used for the treatment of humans and animals, those are also not patented in India. They are not patentable. Okay. And most importantly, plants and animals in whole or part, they are also not patentable, including seeds. There are certain exemptions for microorganisms. Although plant, animals, and seeds, those are not patentable. Again, apart from that, mathematical, business methods, software, those are also not patentable. Softwares are covered under copyright. So that's the reason, they have excluded the patenting of software per se. And software per se, those are not patentable. They are copyrightable subject matters. And more importantly, this 3L, it talks about the copyrightable subject matters like literary works, dramatic work. Those kind of copyrightable subject matters are also not patentable, although they might be invented. Okay. And the designs are also not protected under this. Apart from that, scheme or method of mental act or playing games, those are not patentable. Presentation of information is not patentable. Then integrated circuits, which are being used in electrical circuits, those are also not patentable because we have a separate law on this. And most importantly, when we talk about traditional knowledge, Section 3P of India, it bars patenting of traditional knowledge. Okay, so in case there is an aggregation of known properties of traditionally known components, which in effect are leading to that already known this thing. So those things are also not patentable. This is very important when we talk about traditional knowledge. Although, in case you come up with certain kind of innovative features over the existing knowledge, then those things are patentable, subject to qualifying the essential requirements of a patent. So if you talk about the examples, these are some of the examples which can give you an idea the kind of elements that can be patented. So it includes apparatus, devices, machines. The inventions may also include chemicals, drug, food and their compositions, in fact, biological processes which have been manipulated or made, crafted using human intervention, those are also patentable. However, discovering the biological processes itself is not patentable. Okay, so the patentable subject matters include biological products and processes also. So these are some of the examples which give me idea. So after this, we will talk about copyrights. So basically, copyrights, it protects copyright. We all know. I mean, we all are basically generating copyrights each and every day. So when we talk about copyrights, these rights are given to the author. I mean, the authors of literary, artistic, or scientific creations. So the most important thing that we must understand is when we talk about a literary work. For example, we have written a novel. So there must be a story, or I mean, the center of that novel. So the protection that has been granted under copyright law is for the expression of that story. Okay, not the story itself. Okay, so the essential ingredient that is required for getting a copyright is you have to express the idea in a tangible form. Okay, so you have to, if in case you are talking about a novel, you have to write it down. Okay, so the tangible form of that novel is protected, not the story. Okay, likewise, if we talk about other things like uh, like this thing. Okay, so the essential requirement under copyright law is the originality. Okay, so when we talk about originality in copyright, okay, so it includes two ingredients. First is the copyrightable subject matter should be independently created by the author. Okay, and it must have certain degree of creativity in it. So when we talk about independently created by the author, it must be created by the author himself or herself without copying. So it must be distinct from the existing work. So in case your work is similar to the existing work, then it lacks the originality. Okay, and there have been tests wherein the works of the creator have been compared with the existing works to find out the originality. And when we talk about copyrightable subject matters or the works that are covered under copyright law, then we have basically three categories. Okay, so to talk about the original works, I mean those all three works are protected under copyright law. But if you see these works like literary, dramatic, musical, and artistic work, which are presented in green color, they are essentially required to be original in their expression. Okay, so when we talk about a literary work, for example, a poem, okay, it must not be a copied work from the existing. Okay, it must be created by the author with certain kind of intellectual input, and it must be distinct, completely different from the existing work. Okay. Likewise, if you talk about dramatic works, then the plays and choreographic work that has been done should be original. Okay, and the same principle applies for musical and artistic work also. Okay, but when we talk about cinematographic films, as such, they are not required to be original per se, but they must be a combination of literary, dramatic, or musical work. Okay, but these individual literary, dramatic, or musical work should be original in their expression. Okay, so combination of two or three original works will lead to formation of a cinematographic film, but the individual ingredient should be original in their expression. Likewise, if we talk about sound recordings, then the literary, maybe the song or the musical composition that are being used in sound recording should be original in their expression. Okay, so this is the mechanism of copyright in India. Okay, so when we talk about rights and infringement of copyright, so first we must understand who is the owner. So when we talk about copyright, so whoever writes a poem is the owner of that, I mean the authored poem. So almost each one of us every day creates something which is copyrightable subject matter. Okay, so whenever we are writing an answer sheet, so it has a certain kind of expression, a unique kind of expression done by that the student. So that is also copyrightable under copyright law. Okay, So when we are doing, we are preparing some kind of reports, the way we are expressing, the way we are using the words, those things are copyrightable subject matters and protected under copyright law. And the most important part of copyright is, unlike patent law, it is protected per se. The moment you create a copyrightable subject matter, you get the right. Okay. Although you are advised to get it registered before the registry, copyright registry. But in case you create something by action of law, it gets protected. You have to just mark that it belongs to you and the year of creation. That's it. So that is all required for the to make the public aware that it is created by you in this year. Okay. So this slide, it talks about the rights of a copyright owner. So when you get a copy, you create a copyrightable subject matter, whether it is registered or you get it by action, the action of law, you get certain kind of rights. First right is the right of reproduction of the work. So you can reproduce the work, you can make copies of that work, and you can distribute those copies. You can make public performance of the work. You have the right to control the broadcasting. Okay, broadcasting of that copyrightable subject matter. You can control the translation of the work. So once you have created a work, the translation of work into other languages will also be covered by copyright law. And the last thing is the adaptation of the work. So in case you have a novel and you are creating a movie out of it, those kind of adaptations, those are also controlled under copyright law. So these are the rights under copyright law. But if we talk about the category of rights, basically there are three types of rights under copyright. First is economical right. When you gain, you can earn out of it. You can make copies and sell it. You can license your work. You can get fair return in terms of monetary benefits. So those are the economical rights. Then we have moral rights. So when we talk about moral rights, these are basically non-economical rights given to the authors. So it includes basically three rights. First right is right of attribution. So whenever you author something, you create some kind of copyrightable subject matter, you get a right of attribution. You can always say that this work belongs to me. Okay. Another kind of moral right that is attached to this copyright is integrity. So you can claim, you can claim the integrity in that work, and you have the right to restrain false attribution also. So those are the moral rights attached to the copyright law. Apart from that, we have performance right also. So as we discussed, copyrightable subject matter should be expressed in a tangible form. But when we talk about live performances, so these are the rights which are attached to the performers. So they can enjoy certain kind of special rights. So there are certain remedies in case there is an infringement, somebody copies your the subject matter or your work, then you can have civil, criminal, or administrative measures to protect your work. So these civil remedies, they include injunctions, grant of damages, and cost also. It is there are certain criminal provisions also wherein the police can take cognizance of the infringement, and there are provisions for payment of fine also. And when we talk about administrative measures, these are basically certain kind of measures wherein you can restrain the import of infringing material into the country. So in case you come across some kind of infringing material, like you have created a song, but if you see some kind of copies which contain some infringing material, you can approach the administrative authorities to restrain the import of those items. So now we will talk about trademarks. So we all came across these marks which are being used by either the producers or the service providers. So if you see some of the marks which are given in this slide, you all are aware about these marks which are being used. So these are basically trademarks being used by the business entities. So this trademark law under IP regime is consumer centric. Although it benefits the producer or the service provider, but in a way it is beneficial for the consumers also. So the prime motive of using trademarks is like you must signify that a certain product or a specific service is coming from a identified producer or service provider, so that the public must not get confused. Okay, so the test of granting a trademark is like it must be distinctive. Okay, and that distinctiveness can be inherent or acquired, that we'll discuss. Okay, so when we talk about marks, these are basically marks which can be expressed graphically. Okay, so you have to express this marks while filing a trademark application. Okay, and the mark should be distinctive, as I discussed, and they must have either acquired reputation, or they may acquire during their use also. So these are the marks which are being used by the producers and the service providers as a branding tool. They are being used in market, and they hold great significance in terms of monetary value and and importance. So if you talk about these marks, they include different type of words, designs, signs, symbols, shapes of goods. Packaging is also included. Color combinations are also used as trademark items. So these are, additional marks which are visible to us. Okay, and when we talk about the term of protection, the trademark is protected initially for 10 years, but you can renew these trademarks for another 10 years till you are using them. Okay, and these are licensable commodities. You can license them, you can assign them, you can completely sell them to others, partially or completely. It might happen that you license out your trademark for a certain territory, for few states. Okay, or you just assign it to somebody for use completely. So you have an option. It's a tradable commodity. So this is one of the example which combines the traditional knowledge, how trademark law has helped the traditional community to create a brand out of their efforts. So if you talk about this data, it's an example from Kenya. So there is a Taveta County wherein these data baskets are being manufactured by the communities living there. So it's a very unique kind of art wherein they use sisal plant. So they use the fibers of sisal plant, which is agave, sisalana. And these fibers are traditionally, they have a traditional way of making these fibers and using them for making baskets. So the challenge before them was to have a standardized mechanism. Okay, so what they did was they applied for a collective mark. If you see this mark in orange, which gives you an impression of a basket, a sisal plant, and mountains. So it signifies three elements. One is like the basket that they make, the source of the fibers, that is sisal plant, and the mountains where these people are living. So this mark was also a kind of very laborious activity that they did to make it more attractive. So it was a kind of collective effort that they made. But this mark is being registered as a collective mark. Okay, that means it is owned by the whole group, and they have made specific quality standards. Okay, so it's like in case you fulfill those essential standards or the qualities, then only you can use this mark. Okay, and they have created an association, and out of those activities that after getting this mark registered and using it using them with certain quality standards, the customers, they have established confidence in this mark. Okay, and they are recognizing it. So in a way, this IP tool of trademark law was being used to preserve traditional knowledge. This is one of the examples, but we have several other examples of using IP tools for protection of traditional knowledge across the globe. Okay, so then another kind of tool that is being used in IPRs is the industrial designs. So basically, if you talk about industrial designs, it refers to the shape, configuration, or surface patterns which are being applied on the articles. Okay, and the most important part of this tool is that industrial design protects the aesthetic or ornamental aspect of the product. So if you talk about these bottles, the aesthetic or ornamental appearance of these bottles are protected, not the functionality. Okay, so whatever we see is protected under this law. Okay, it may include shape, configurations, surface patterns, as we see on the shoe. It may include patterns or ornamentation. It may include composition of lines or colors, And the mechanism being used for application of these designs on the articles, it may be manual, mechanical, or chemical. There is no restriction. It can be combination of these three also. Okay. So whatever we can see from our eyes is protected under industrial designs. The only test is like it should be original. And when we talk about originality under industrial designs, that means it must be originated from the author. It has to be the independent work of the author, and it can include cases wherein you have applied a single design on a different article. To give you an example of this, you can assume that in case you have a curtain with this blue flower design which is on the shoe, so you can have a registration for the curtain wherein you have applied this design on the cloth of a curtain. But in case you apply that design on the shoe, then you will have a separate registration, because applying this design on this shoe will require another kind of creativity, because you have to arrange the motifs and the design in a way that it suits well on the shoe. So both the articles will have separate registrations under this law. So there are certain restrictions also. There are certain items which are not registrable under industrial designs. So first is, in case you are applying a design to the inner portion of an article, which is not visible or noticeable by the viewer, then those articles or items are not registrable under design set. To give you an example, if you have a watch wherein you have designed some internal elements which are very unique, just because this while looking at this watch, we can't see those internal elements. That's the reason those things will not be protected. However, the appearance of watch, which you can see by our eyes physically, those things are protected. Okay, so it's a test which says whatever is visible is protected under industrial designs. Okay, another thing which is not protected under industrial designs are buildings and structures. Okay, and another important thing is when a part of an article which is not sold separately, okay, which can be sold separately, has to be registered separately. So in case an article is combination of two elements which can't be sold separately, they two combine to make a single article, then the registration should be for the single article. In case you can detach these two items and sold them separately, then you can have two separate registrations. Okay. Then the variations which are common in trade are also not registrable. So miniature model of some kind of article, those are also not registrable. Stamps, labels, tokens, medals, trademarks, cards, cartoons, these are also not registrable. Mere changing the size is also not registrable. Emblems and flags of nations, those are not patentable. These registrable under the industrial designs. Computer chips and integrated circuits are also not registered just because we have a separate law. So when we talk about the protection of industrial designs, basically the initial registration is given for 10 years, which can be extended by another 5 years. Yes. So now another tool that is being used in IP is geographical indications. So basically we all have heard about geographical indications. So we all know Darjeeling tea, it's a geographical indication. We know Nagpur orange is geographical indication. So basically these are the signs or marks which are being used. Okay, these are used on products. For services, GI is not available. So basically geographical indications are marks or signs used on products, okay, which have a specific geographical origin. So we all know Darjeeling tea originates in Darjeeling. Okay, so this Darjeeling tea, which is the geographical indication, is being used to signify that Darjeeling tea originates in Darjeeling. But the most important part of having a geographical indication is that the product must have certain kind of quality or reputation, and that quality or reputation that it has must be linked to its origin. Okay, So when we say Darjeeling tea, then it has a specific aroma, and that aroma is critically attached to its origin in Darjeeling, in that specific region. Okay, so it's a kind of sign which gives, which signifies the origin of a specific product having certain kind of reputation or quality. And we have a lot of products being registered in India under GI Act. And if you talk about the duration of protection, initially the registration is the protection is granted for 10 years, which can be renewed for 10 years till you are using it. And the interesting part is the applicant in this geographical indication application should be an association working for the benefit of the artisans or the people who are cultivating or making those geographical the products covered under geographical indications. And when we talk about the coverage, it may include agricultural products like Darjeeling tea, Hero turmeric, Guntur chili. It can be, those products can be naturally occurring. For example, red sandstone or Makrana marble from Rajasthan, or they can be manufactured. When we talk about manufactured, they can be handicrafts. They can be manufactured in the industrial goods or foodstuffs. There are a lot of examples. Some of them are in this slide. So this is the geography and the key attributes that we discussed. So when we talk about geographical area, the product must originate in a particular geographical area. So there must be a defined area where that product originates. And when it is a processed product, then at least one stage of preparation, processing, or production is done in that area. Okay, and that area should be defined. So you have to submit a map giving the details of the territory, because it has to be defined. The territory has to be defined in the application. And the reputation that we are talking about is like it must be distinctive in nature, in expression. So the nature of goods can be one, quality itself, established repute either domestically or globally, or any other characteristic feature which you think can increase the reputation of the product. Okay, and there must be a linkage between the reputation and geographical area for that given quality, or the environment that location has, or the kind of materials you are sourcing from that area. It may also include kind of human factors also. When we talk about Banarsi sari, the weavers in that locality, they have a specific, they have specific skills which are required for making that sari apart from the local materials that they are using. So this is a kind of coverage for GIs. This is one of the examples wherein there was a dispute with regard to registration of Bangar Rasgulla and Odisha Rasgulla. So it was a kind of there was an argument with regard to the origination of these Rasgulla. But while these applications were examined, it was found that these two items are completely different, originating in two different states. So the applicants, the applicant and the opponent, they were advised to have two different GIs for these two products, because they differed in color, they differed in texture, and they had different taste also. So now we have two different GI registrations for almost a similar product, which is a kind of having different characteristics which are linked to the geographical locations. Like one is in the West Bengal and one is in the Odisha. This is another example wherein the traditional knowledge is being used in contemporary time. So this around the Konkan region, these Wali paintings are being made. Okay, so when people from this region, they know that during the festive seasons, or the occasions, the family occasions that we have, the people they make these paintings on the wall. Okay, and these kind of paintings, they are made on mud walls with white paste, and this paste is prepared traditionally using rice, water, and gum. And the brushes that they use to make these paintings are also traditionally made using bamboo sticks. And the best part is these paintings are basically, they sing some kind of songs which and during singing those songs, they express those songs on through these paintings. So it's a kind of traditional way of expressing those songs onto the walls. Okay, so if you see the application which has been filed for registration of early paintings, originally or traditionally they were being made on the walls, but the application, it talks about 3 classes of products, wherein the application says that these Worley paintings will be applied on the items covered under class 16, which include paper, notebook, cardboard, plastic fiber, and it also include class 20, which include items like wood, plywood, furniture, and class 25 comprising canvas, cloth, and garments. So an art which was traditionally made on walls will now be used on certain other products for which the application has been granted. Okay, so it's a kind of convergence between traditional knowledge and contemporary word. So the plant variety protection is another tool wherein we can protect the varieties, new varieties. Okay, so it's a sui generis law. Unlike other countries wherein we can get patents on plants, in our country we have to go for we have to follow this law, which is the Protection of Plant Varieties, Protection of Farmers' Right Act of 2001, under which we can get our varieties registered. Okay, so it's basically, the law has a motivation from the standard law given by International Union of Protection of New Varieties of Plant, which is known as UPO, which was established in 1961. Although we are not a signatory to this UPO, but what the law that we have enacted in our country is UPO plus, because our law talks about the rights of breeders, it talks about the right of farmers also, and researchers' right. So it's a kind of unique law enacted, aligning to the domestic need of our country. Being an agrarian country, we have taken care of the rights of various stakeholders there. So if you talk about the requirements for registration of new variety, so the distinctiveness, uniformity, and stability is required for getting a plant variety registered. And if you talk about the kind of varieties that can be registered, so you can register a new variety, extant variety, farmer's variety, or essentially dried variety. So we'll be sharing the slide wherein you can go through the criteria which is required for registration of these varieties and what are the rights conferred and the kind of duration that they give. Okay, so in case some of you, you might be working in the field of plant variety or breeding, so you can go through these slides in detail. So this is another example of an IP tool being used, although it is very not so famous as compared to patents, copyright, or trademarks. But it is, it is enacted in India to protect the layout design of semiconductor integrated circuits. So when we talk about these, electronic circuits, the electronic gadgets, you might, if you have seen your devices, you might have come across these kind of arrangements which can be seen on the PPT, wherein there are certain chips and microchips. Okay, so the protection that is given for these circuitry elements is like the layout design of this circuitry element is being protected. So managing these and designing this circuitry element is itself is very tedious task. Okay, so we all know that converting a big product to a smaller product in size, it requires a certain degree of intellectual input and effort to make a miniature model of it. So that's the reason these layout designs of semiconductor integrated circuits are protected under this specific law that is there in India. Okay, so these are basically you can find it in computers, watches, and several other electronics and electrical devices. So if you talk about the protection, then this map that you can see, it's a layout design. It is protected. Okay, so the protection is not granted for the product, but the way you have arranged these integrated circuits, which includes transistors and circuitry elements and lead wires. So this is protected under this law. So when we talk about essential requirements, then the layout should be inherently distinctive. That means it should not have been copied from the existing one. Okay. And another requirement is it should be capable of being distinguishing it from the existing works. Okay. So these are the two essential requirements, and in case it is published somewhere 2 years before then or commercially exploited, then it is not registrable under this layout design act. Okay. Although combination of two or more layouts leading to a distinctive expression leads to registration. So this is a kind of arrangement given for the registration of layout designs in India. And when we talk about the duration, it is for 10 years, and it is counted from the date of filing application of first commercial exploitation in India or else. So to summarize, we have discussed certain kind of tools. So this gives you a proper overview. So when we talk about copyright and related rights, it covers literary, musical, and artistic works. Examples are books, sound recordings, cinematographic films, poems, etc. Patents are granted for inventions. Some example is vaccine and drug. Then trademarks, certification marks, or collective marks are given for the marks being used for distinguishing a product or service of one from the others. So one of the example is Coca-Cola. Then GIs we have already discussed in detail. Darjeeling tea is the best example, wherein a mark is being used to signify the origin of a product which has a specific reputation. Industrial designs, it protects the aesthetic element of a product, like a basket. Then we discussed about layout of integrated circuits and plant varieties. So this is an overview. We'll be sharing the slide wherein you can go through these things in detail. So if we talk about the understanding, there are certain conceptual similarities in IPRs, and there are differences also. So when we talk about similarities, it is granted for product or a process of intellectual activity. And there is a specific criteria for each tool which is to be fulfilled for registration. It confers exclusive rights also for a limited period. Okay. So when we talk about patents, it's 20 years. When we talk about copyrights, it's 60 years after life, starting from the first calendar day of the next year after that. Okay. There are certain limitation and exceptions with regard to use. So there are fair use exceptions for copyright law in case you are using that information for certain exceptions, which wherein one is R&D in teaching. So those things are excluded. Those will not lead to the infringement. Okay. And when we talk about differences, there are the subject matter of each tool is different. For patent, it's invention. For copyright, you must go, author a literary work or a dramatic work. And these are different. Subject matters are different. Then requirement of grants are also different. Conditions for protection are completely different in all these tools. Then the nature of rights are also varying from one tool to another. And duration, as we discussed, duration is also variable. Okay. So to summarize, IPRs are being used as a tool of creativity and to get a fair return over the investment that you have made. So when we talk about patent designs and copyright, they enable the creator and innovators. However, if we talk about trademarks, they are consumer centric. When we talk about GIs, they are also, giving a consumer kind of confidence that this product is coming from that, or a locality. So these are basically used as branding and financial tools. But if you see overall, the whole of IP tools that are available, they convert creative ideas into assets. Okay, and it enhances the business level, give an edge over the competitors to the innovators. Thank you. This was all about the IP tools. So
Yes, sir. Thank you very much for your informative session. So, sir, let us complete the assessment quickly. Then we'll come back to our question and answer session.
sure.
So we request all the participants, please complete the assessment within 10 minutes. We are sharing the link in the chat box, and it will be uploaded in the Google Drive also. Now it's 4:30. Please complete the assessment within 10 minutes. You have another 1 more minute. Please submit your assessment. So we hope you have submitted your assessment. So whoever has submitted, please put your questions and queries in the chat box. So we request all of you, please put your questions in the chat box so we can address your questions. Namaste, sir. Namaste, Anil, sir. Can we start?
Yes,
with
yes,
few
please.
questions? Yes. So there is a question from Dr. Lavanyaji. Can we apply for a GI which is not related to revenue generation? Question mark. Based on historical specification, may we get GI based on historical specification?
Yes. So basically, when we talk about GIs, those are granted for products only. So the question is whether it is GIs, we apply for
Which
a
is
GI
not
which is not
related
related
to
to revenue
revenue
generation.
generation.
Basically, we get it for products which are being commercialized. Okay. So registration तो आपको मिल जाएगा. Okay. in case you fulfill all the essential ingredients, it's your choice whether you want to trade that product or not. But basically, protection is given to protect your investments. No. So in case you are doing some kind of branding, so you will require some
Yes.
kind of investment. But in case your motive is not revenue generation, then also you can get a GI register. There is no bar.
Uh, Another question: does copyright have any time limit of protection? What is the time limit of
Yes.
protection?
When we talk about copyrights, it's for a limited time. Okay. So when we talk about a literary work done by an author, then the protection is for the lifetime of the author and 60 years after his death. Okay. And that 60 years will start from the 1st January of the next year, when he died. So it's a life plus 60 years.
Yes.
But for government organizations, in case there is any publication, so there is no life, I mean, we can't attach the life, then there is a definite period.
Yes. What is the difference between patent published and patent grant?
So the difference between a patent published and patent grant is like, well, so there is a process of filing patent application. So you have to prepare a patent application and file it. And it has to be published so that the public should know that such kind of invention is being filed for grant of patent. Okay. So there is a time limit of this publication. After 18 months, these patent applications, normally they get published. Okay. But you can get your patent application published early also. So this is a kind of information given by the patent offices that such kind of patent has been applied. Okay. But patent grant is like the whole process is completed. So after patent is published, it is examined, okay, by the patent examiner. And after fulfilling all the processes, it is granted in the end in case it fulfill all the essential criteria. So patent granted is like you have been granted a patent for that invention, and patent published is like your application is published, but it is yet to be examined and granted.
Yes. The next question: who can apply for GI? Is beneficiary only? Question mark.
So the law says an association who is working for the benefit of the stakeholders. Okay. So in case there is any artifact, so an association working for the benefit of those artisans, they can apply for a GI application. So there are two kind of categories in GI. One is the applicant, which is an association, and there is a register wherein the registered users are registered. So for example, ABC Association working for a ceramic article, he will apply for this GI application. But the craftsmen working on that product, they will be registered, they will get themselves registered as registered users. So there are two different categories. But applicant is an association.
Yes, sir. So another question regarding publication copyright. I have published from Dr. Runaji. I have published articles in Routledge journals and I have signed a copyright agreement with each. Now, if I want to publish a book with those articles as chapters, should I write to editors for the same or will they grant me the right to publish or republish?
So it depends on the agreement that you have signed. So you must have gone through the terms and conditions. Okay. So this agreement that you have signed is an I mean, it talks about the usage of your copyright, whether you have waived, what kind of copyright you have waived, what kind of rights you have transferred to the other party. So it is completely governed by the terms and conditions of that agreement.
Yes, can patents or copyrights be claimed for the traditional Indian performing art? That's the question.
For art, patents are not granted. As we discussed, patents are granted for inventions. Okay. So in case we are saying performing art, so that doesn't qualify, okay, under the legal scenario. But when we talk about copyrights, yes, the performances, they are protected in case they are innovative. But there is a duration for protection also. And the essential parameter is they must be original in their expression. Okay. So in case it's completely, I mean, it's a kind of test that you have to fulfill. So we talked that originality is one of the essential parameter for getting a copyright register.
If we use technology and integrate ancient wisdom, can that be patented or copyright?
Can you please repeat your question?
Yes. If we use technology or integrate ancient wisdom, can that be patented or copyrighted?
Again, I believe
Technology.
this is something, I mean, same to what we have discussed in the previous question. So for patents, there must be an invention. Okay. So there must be an invention which is having technological advancement over the existing thing. It can be a product or process. Okay. And it has to fulfill the essential requirements like I talked about novelty, inventive step, utility. So in case your combination of the elements, they fulfill all these parameters and they are not falling under section 3. Okay. Section 3P specifically talks about the traditional knowledge, which I mean something which is in effect is traditional knowledge is also not patentable. If you fulfill all these essential criteria, you will get a patent. There is no bar.
Yes.
Yes.
Thank you, sir. So there is a good question from Charlotte ji. Is there any depository or to search all registered IPRs? How can we check our application is novel?
See, there are separate authorities for grant of these IP rights. So when we talk about patents, so we have patent office located at various locations. So they publish through journals and the information is also available on website. So you can use the website for, I mean, looking for your own application, the status of your own applications, and you can look for the information which is already there, publication of other patent applications also. Likewise, we have trademark registry. It is also having different locations. So whenever when you file a trademark application, so you can see your application there and you can see the others application also. You can make a search out of it. Likewise, we have different authorities wherein you can see your applications, you can look for others, you can make search, you can see what things existed and all those things. So all the resources are available. So you have to just look for the proper authority for the information that you are looking for.
Yes, the next question, can software code be patented? Actually, it is an algorithm, a unique method of image processing, especially designed for reading Grantha script, and it is tied to a dedicated hardware instrument. So can software code be patented? That is the main thing.
If you talk about copyright or copyright codes, copyright is software. If you talk about a software or the codes, those are copyrightable subject matter. So copyright per se is this software per se is a copyrightable subject matter. This is the law. But in case you couple the hardware with the software, wherein that software is exclusively used for that hardware, so you cannot disintegrate these two, then there is a possibility of getting a patent over it. But that will not cover the codes. That is it. So law is very clear.
Yes,
We have several
yes.
judgments governing this. Yes, please.
Sir, regarding copyright, when to apply for copyright of a book you are writing, before contracting a publisher or after?
So basically, it's a kind of strategy that you have to use. It's a business strategy. Okay. So when you are approaching a publisher for publication of a book, okay, so they will also have some kind of rights. So being an author, you have your own rights. While approaching them, you have to sign certain agreements having terms and conditions. So it's a kind of no giving away your rights to the publisher. So those terms will govern, but it's a business decision you have to take. But as far as an author, you can apply for copyright at any stage. Okay, so you can register a book in your name, and then you can register the work and then approach the publishers, or you can approach the publishers, then they will have kind of no combined publication that they have, but you will remain the author. So the rights of author and publisher, those are properly defined under copyright law and will be governed by the agreement that you will be signing. Yes.
So we can take one or two more questions. So,
Yes.
sir, what does benefit of consumer mean in case of trademark?
Yes, although these trademarks are assets for the producer or the service provider. So when we take an example of Coca-Cola, okay, so the name Coca-Cola or the logo that they use is an asset of company. Okay, so it's an intellectual creation of the company and it's an asset for them. But if you see the application of that trademark, it in a way signifies that the product which has those marks or logos comes from a producer who is ABC. Okay, so it gives a clear indication to the consumer that you can trust this product. So the reputation that is attached to the trademark in a way helps the consumer to make a decision whether you should buy that product or not. Okay, so that's the reason I said that trademark is a consumer centric law. Although it's an asset, it's an IP asset for the producer or the service provider, but it helps the consumers to arrive at a decision and they can trust the product.
Yes. Another. From Vinod ji, we have seen many Chhattisgarh tribal. Many tribal communities possess valuable traditional knowledge. However, during field surveys, some PhD students collecting this information, especially related to traditional medicine practices, later they slightly modify the formulas and claim them as their own innovations, especially related to, innovations. Are there any laws or IPR rules that protect the rights of these tribal communities or provide them the recognition or royalty support?
See, as I already, we discussed about the Section 3 of the Patents Act. It says, Section 3P, it says that something which in effect is traditional knowledge is not an invention. So although it is an invention in terms of as per the definition given in the law, but in case it is in effect a traditional knowledge or aggregation of the components, so then that is not patentable. Okay, but in case you make some kind of improvements, okay, during your PhD thesis, then those improvements should be they should be in a way overcoming the meeting the essential requirements, like no, it must be inventive in nature. Sufficiently inventive to overcome the bar which is there in Section 3P. तो इसको हम ऐसे देख सकते हैं. For example, in case, we have already gone through that. We all know about the case of the turmeric. So the turmeric was being, a patent application was filed in US for getting a patent over the therapeutic use of wound healing properties of turmeric. That was turned down because it was not inventive. Okay, so in case you come up with some kind of inventive concept wherein although you are using the ingredients which are there in the turmeric for treating wounds, but in a different way, Okay, so in case you are reducing the toxicity level, it's an example. I'm not saying that this will be done, but in a way, in case you reduces the amount which is used for treating the wound, or you reduces the toxicity, which was one of the problems existing in the prior art or the existing technology, then those things can qualify, subject to the satisfaction of the examiner. Yes.
Last question, then we can close. Is there any example to file a patent from social science perspective? Social science for
Social
patent.
science patents.
Hmm.
Social science patents. Basically, patents are granted for a product, okay, or a process. So a process which addresses a problem existing in social sciences. What can be the example? Yushi, can you think of social sciences as like?
It's more related to copyright, but
It's more
for
related to
patent,
copyright. But in case there is some kind of technological intervention, then definitely we'll get a patent.
yes, we'll try to find. If we find, we can address in our interactive session.
Yes.
Okay, I will accumulate. So it's time to close. Let's close today with mantra. Then see you. We thank you all the participants. Oh. सर्वे भवन्तु सुखिनः सर्वे सन्तु निरामयाः सर्वे भद्राणि पश्यन्तु मा कश्चित् दुःखभाग् भवेत् ॐ शान्ति शान्ति शान्तिः pranam sir, pranam all the
Thank you, everyone.
participants. See
Thank you,
you
Kristi.
tomorrow. Yes, see you.